Good afternoon. My name is Don Vivrette, and I welcome you to our webinars. We are going to go through as we have in the past, and so let me advance this guy, another one. There you go. It's Your Estate is what we're going to be talking about today in terms of how we'll go through that. For those of you who were with us yesterday and you know that I screwed up and did not start the recording immediately, it's recording so that I haven't messed that up twice. Just as a note for you, there's 300 of you who have registered for each of the two sessions, 200 of which are overlaps. The material is at materials and itsyourmoneyandestate.org. The presentation should be up basically the next day, other than yesterday's, which we have to fix. That's a whole nother story. You cannot turn on your audio or your video. If you move your mouse or tap your screen or something, you can see a little Q&A. That's where you want to type in your questions, and I will get those and I will ask them as we go along. They're also recorded, so we are going to cover some of the ones that we've put off from prior weeks will be covered today, and others will be covered as we go along. If you go into the estate, the materials at It's Your Money and Estate, you'll see this banner. If you click down in terms of the week that you want, so the different weeks are here. I just happened to pick the first one because it was on top. It will show you at the top will be the video recording once that's finished, and then all the handout material. There's a lot of articles and other things in there today. And so I urge you to take a look at them, browse through them, and see what you want. The question has been asked before of who are the sponsors? Where can we find out? Same website, over to the side. There's a tab there that lists the various charities and nonprofits that we deal with throughout the time. There is this button somewhere between my picture and the screen, and you can move that left or right, and it will shrink me, which is probably best, and enlarge the text, which is the important part. Also, that Q&A button, again, you click on that, type in the information, and I will be monitoring that throughout the time. Next thing is, so today we are talking about living trusts. Next week, just as a promotional thing, I'm going to be giving the charitable giving module with David Moore from Chapman University. So that will be next week's session. Please attend. Don't think we're asking you to give away money. We actually want you to make money while you're giving away money and understand that concept. So I would urge you to think about being a part of that one next week if you can. These are the physical locations that normally we are at during the time. We want to give them a shout out in terms of thank you for supporting us over time, and hopefully all things work out, and in the spring we can be live again and do those. These are the participating charities that we have. As I do every week, Chapman is a sponsor for 10 years. We thank them very much for being here and being a part of it. Normally at the live sessions that we do, someone comes in from the nonprofit and talks to us in terms of what's going on about their nonprofit. That we chose not to do this time because nothing is in person. So therefore what we have done is to say, let's do them virtually. This week is Laguna Beach Seniors is going to have the video that I'm going to show you in just a minute. So I'm going to work through getting that brought up. So hang on just a minute. I want this, share, go, end, that. Oh, we seem to have gone away. Good afternoon. Kote, why don't you give us an overview on Laguna Beach Seniors?
I'm Kote Engel, President of Laguna Beach Seniors. Part of the focus of today's program is how to enjoy your life. Living it up for those of us over 50 is the mission of Laguna Beach Seniors at the Susie Q. Here's a quick look at what's going on at the Susie Q.
Laguna Beach Seniors was founded in 1975. Our mission is to use programs and services that enhance the seniors' lives and promote wellness, education, and community. For example, we have a program called Feeling the Blues. We provide 10 to 14 free sessions of one-on-one therapy to seniors who are depressed or isolated. The senior who has completed their therapy sessions, all of a sudden engage with the programs here. They sign up for classes, they attend a music class, we learn how to play ukulele. This socialization in their lives is enhanced because of that life-changing program.
Now let me tell you what's happening now. When the COVID virus meant closing the Susie Q building, Our terrific staff and board quickly organized the Suzy Q Without Walls. Within a few weeks, we are offering virtual programming. The number of programs has been increasing each month, and we will soon have 50 programs online. So far, over 40,000 seniors of all ages have participated. One of the unique aspects of Laguna Beach Seniors is that, unlike most senior centers, which are operated by the local government, the Suzy Q is financed almost entirely by contributions from people like you. As an independent nonprofit organization, we've been able to quickly adapt to the needs of the community and initiate innovative programs that meet those needs. To assure the Suzy Q continues to provide a place to live it up, we are asking you to consider including Laguna Beach Seniors in your estate plan. A gift to Laguna Beach Seniors is a legacy of which you and your family can be proud. To learn more, simply go to thesuzyq.org. Thank you and enjoy the program.
Okay, so let me stop sharing and I come back and Pete.
Yep.
Hello, Pete.
Hello.
So what I'm going to do is, because I monitor the questions, the Q&A that come through, and there have been several of you already, but I realized when I brought it up, I put it up in the middle of that video. So I shut that down, so I will now start reading it. So I'm going away. Pete and Blaine are going to go through and discuss what all needs to be discussed today. I will appear occasionally to ask questions, and I will be back at the end. So tag, you're it, Pete.
Okay. Hello, Blaine. I'm going to introduce you in just a second, and hang on there. Just want to mention that, Laguna Beach Seniors is awesome group, and we really appreciate their support. But there's lots of senior communities or senior centers or community centers in Orange County. And I encourage you to attend when the opening comes back up and have a meal with other people. Social isolation, what we're experiencing now, is just the worst. And that's when people get into trouble. We're social animals and we need other people around us. My mother was 98 when she died just about 9 months ago. And we tried to get her to a senior center 3 times a week. And she goes, the senior center is for old people. So she didn't think she was old. So, but even her, she needed somebody to complain about. So we all need other people. And I encourage you to volunteer or give to other organizations, and especially in this time of need. Today's topic, we're going to focus in on living trust. And just to kind of give you a review of what we did in the past, we went through the whole probate, what probate was about, how important title is. You should know and have a list of all your assets as to what the asset is, how you have it titled, what is the cost basis, and what is the market value. And a living trust is going to be, we're going to talk about today, is one of the ways that you can have title to your assets. And it's one of the most difficult areas to understand and comprehend. So luckily, this is going to be taped. And Blaine, our speaker, Blaine, come on back on. And who's been doing this for over 16 years and exclusively in the estate planning area. Why don't you bring up your outline, Blaine, and we'll go through your Ask First form as we do all of the presenters.
You got it.
All right. So first thing is, you have a master or other advanced degree. Where did you get that degree from?
Yeah, so my JD is from University of Oregon, go Ducks, and my master's in tax law is from Georgetown University.
Okay, and is that what an LLM means?
It is. It's a lovely Latin term. I think it's legum magister or something. It sounds like beans to me, but yes, it's a master in tax laws is what it stands for.
Okay, give me a little background on your 16 years of experience, and also, do you just practice exclusively in the estate planning area?
Got it. Yeah, thank you. So fresh out of college, I spent about a year and a half working for an accounting firm doing some tax consulting here in Orange County. And then since then, I've spent the last 15 or so years practicing law, doing estate planning. So with my tax background, I really get involved in estate planning, from very simple estates all the way up to the complex estate plans that we have with some of our clients. And then I also do about 50% of my practice is regular business representation. So mergers, acquisitions, entity formations, buying, selling businesses, and so forth. So anything with kind of a tax flair to it. And then a particular emphasis in property tax planning for many of my estate planning clients.
You have kind of a unique law firm in the sense that how many attorneys do you have just in your estate planning section?
Yeah, so it's interesting. So just in the estate planning itself, we have 3 of us attorneys who do the estate planning, who meet with clients and do this day in and day out. As an aside, we also have an entire department dedicated to trust administration. So when someone becomes incapacitated or passes away, then the trust has certain things that have to happen. And so we have attorneys, I think the count now is 4 attorneys who help with that. And then finally, we also have an entire department dedicated to probate and trust litigation, which unfortunately pops up quite frequently here in Orange County. And there we've also got about 4 or 5 attorneys who do nothing but that litigation, that court work, if you will.
And you are local. In other words, you don't have 150 offices over the United States.
Just one office here in Newport Beach.
Yeah, it's really a unique firm. Let's get right down to how are you paid? How if somebody comes into you, has $1 million, I'm single, I have one property, I have an IRA account, and I have an investment account. How much would you charge me to do my estate plan?
Yeah, great question. So the way that we work is that we will offer an initial 1-hour consultation, and that would be for half of our usual hourly fee. In my case, I'm $4.50 or $4.25 an hour, so it's half of that amount. And then to the extent that I meet with a client and they decide to engage us going forward, then we just take that number and we wrap it right into the flat fee that we would use to prepare an estate plan. So the numbers that I've given you here, $2,800 to $3,500 would be the typical cost for an estate plan for a married couple, and that would be preparation of a trust and 2 wills, powers of attorney, advanced healthcare directives, assignments, and also preparing a deed to transfer their house into the trust. For a single individual, that price is usually about $1,800 as a flat fee to do all of those things.
Okay, great. And then you sign, you're not associated with anyone who take referral fees or kickbacks for an annuities, insurance, or anything of the kind?
Correct.
Okay, that's what we want to hear.
Yeah.
Okay, you've got the huge task of trying to explain a living trust to people who are not aware of the terminology. Yeah. And the concept, because it's a fictitious thing, a living trust. It's just on paper. You can't eat it. Take it away, Blaine. It's all yours.
All right. Well, thank you, Pete. Listen, I really appreciate the opportunity to speak to all of you today. And, Don will circulate. He'll pull up some questions. We've got some other questions. We'll try to just filter those through as we go along through our presentation today. But what I hope to talk about are these 4 things. And by the way, my presentation here, the slideshow should be up on the website, if not already, so you can access it. Just know that especially those sections, those slides dealing with property tax issues, we will address those if we have time at the end. But really, I threw them in there for more informational purposes. So if we don't have time to get to those, don't fret. You've got the information to look at. And quite frankly, with the election coming up in November, a lot of those may be changing anyway. So I guess we'll see what happens. But let's start off kind of fundamentally and talk about what is a trust and why do we do the trust. Now, I know that you've spent some time already with a previous speaker or speakers and with Pete talking about probate. And so one of the big reasons that you will do a trust is to avoid this whole probate process. And I'm not going to go into a lot of detail, but suffice it to say that especially now during the COVID times, if you're doing a probate, in regular times, you're looking at 9 months to 15 months to finish that process. In COVID, it's anybody's guess, maybe 2 years to do that. So it's
2
really
years.
slow. The other thing is in the probate process, you're filing documentation with the court. You have hearings in court that anybody can walk into. So much of that is public, and it's out there for the world to see what kind of assets the decedent owned, who are the heirs and the beneficiaries, and that may not be something that you want to broadcast or disclose to the whole world. And then finally, of course, one of the big reasons that we want to do a trust to avoid probate is because probate's expensive. And I think you've probably talked about this before, that there are statutory fees. And based on my calculations, if you have $1 million estate, and by the way, that's $1 million of fair market value, not the equity, if you will. So if you've got a $1 million home that you paid $900,000, you've got a $900,000 mortgage on, you're going to be paying your executor and your attorney based off of a percentage of the fair market value, not the net value. And that cost is about $23,000 per person. So you're looking at just under $50,000 to go through that probate process. So it's not a pleasant experience, but that's why we talk about having a trust. And so think of a trust as we go through and talk about this today. Think of it as creating a box. And what you're going to do is you're going to create that box, and you're going to write on the side of the box your rules, what you want to have happen with the assets in that box. And then what you're going to do is you're going to put those assets into the box so that when you pass away, you aren't the owner of those assets, and we don't have to go to the court to get the court to bless, whoever should be the recipient of those assets. Instead, your box or your trust continues to exist after you pass on, and we get to circumvent that whole probate process altogether. So that's one of the major reasons that we do that trust. Another important thing to think about is, a lot of people mistakenly believe that when you die, if you don't have an estate plan, that the state or the federal government is going to take all of your assets. And that's not the case, of course. The state of California actually has what they call intestacy laws, which means the laws that kick in if you don't have an estate plan. And those intestacy laws will provide for a spouse and children, but it may not be in the same percentages that you have in mind. And furthermore, maybe your beneficiaries that you would want to receive those assets, maybe they're age 18 and it's not a great time for them to receive a large windfall. Maybe they're not responsible enough. So one of the high level benefits of doing a trust is that you get to dictate how those assets are going to pass on to the beneficiaries and when those assets are going to pass on to the beneficiaries.
Talk a little bit about, Blaine, the reasons for having a trust today. You talked a lot about at death, but what if you have Parkinson's or Alzheimer's, or you're in an auto accident, incapacity of some sort?
Sure. So, I have clients who come in pretty frequently and tell me that they have these life-altering illnesses. And so it's really important to put that box into place, because we're not focused as much as to whom those assets will pass when you die, but we want a game plan put together so that if you become incapacitated, that the trustee, and we're going to talk about who that is, an individual that you designate in your trust document, he or she is going to step in and manage your trust assets for your benefit. They're going to go out and they're going to invest those prudently for you. They're going to take those and they're going to use those to pay for your living expenses, your medical expenses, all of those types of things.
So it's really it could likely avoid the whole conservatorship and having to go to court.
Yeah. And the concept of a conservatorship, we won't get too deep into that, but the process is, if you have money in your own name and you lose the capacity to be able to manage those funds, then you have to go into court and get a legal representative appointed to take over those assets for you. And to Pete's point, if you set up that trust and you properly fund that trust, then when you become incapacitated, we get to skip that whole court process altogether. And instead, again, we follow the terms that are in your trust for that person to step in and manage those for you.
Yeah. And that's kind of why I really encourage single individuals who are not married, don't have title in both names, to have a living trust just for that purpose.
Yeah, it's a great
Yeah.
point, Pete.
Yeah, let's go to the next slide.
All right. Okay, so let's talk about the parties to a trust. There are three parties, and it's going to feel slightly schizophrenic here because you're going to see really quickly that when you set up a trust during your lifetime while you're healthy, you're essentially going to be all three parties. Okay, the first party that we're going to talk about is the settlor, sometimes referred to also as a grantor. And that's you, and you are creating that box. And when you put that box together, you're going to identify who you want to run things when you're not around. And again, that's the trustee. You get to designate who you want to receive those assets when you're not around. Those are the beneficiaries. And you're going to sign that trust document to create it. Then comes the tricky part, and that is to fund or put the assets into the box. Now, I have it happen a lot of times where my clients will walk in and say, here's a great trust document I did with my attorney 10 years ago. And I'll say, wonderful, are your assets in the trust? And they'll say, what do you mean? What are you talking about? It doesn't do you any good to have this trust put together if you don't properly fund the trust. So what does that mean? It means going into your bank and telling them, here's a copy of my trust, or what we will sometimes do is prepare kind of some excerpts of the trust just to give the bank enough information that they need to know to actually change the title over from Blaine Searle individually to Blaine Searle, trustee of the trust, the Searle Family Trust. So that's how you would fund an asset. As it pertains to real estate, that means going in and actually physically recording a deed to transfer title from your own name into your trust. With things that don't have a piece of paper attached to it, then what we would generally do is do a bill of sale or a general assignment. I'm transferring all the tangible personal property that I own, my furniture, my artwork, my tea set, my gun collection. I'm putting that all into the trust so that it's clear that that's in place.
And that's called an assignment?
Yeah, an assignment of tangible personal property. Again, sometimes you'll see it referred to as a bill of sale, where you're actually selling it to yourself for, a nominal amount, right? You're transferring that into the trust. And then finally, there's this whole category of other assets that you can't actually transfer ownership in, like a 401k or an IRA, right? And in those cases, there are some beneficiary designation forms that you need to do. And you may decide with the counsel advisement of your attorney that it makes sense to designate the trust as some of those assets also.
Yeah.
So
we're going to go into an hour and a half on that issue
Exactly.
the next 2 weeks from now.
Exactly. Yeah.
Let's go to the next slide.
Okay. So we've talked about the settlor. Let's talk about the trustee. And again, the trustee, think of the trustee as the manager of the trust. And again, kind of schizophrenic, but when you set up the trust and you're healthy, you get to manage all of your trust assets by yourself. So anything that you were doing before, buying, selling, giving away, you get to continue to do all of those things. But as Pete has highlighted, it's essentially important to the extent that you lose capacity, that you have somebody that you name to step in and to manage those assets on your behalf. Now, that trustee doesn't get to do things willy-nilly. There's a whole set of rules that are set forth in the trust document as to what she or he should do. And ultimately, there's also a whole set of fiduciary obligations that are imposed by law that require the trustee to do certain things, like prudently invest those assets, and to refrain from doing certain things like self-dealing, right? So some of the questions that we get here, there's a question that said, what do I do if I don't have any family or friends who want to take on the responsibility of being a successor trustee, right? What do I do? Well, you have a number of choices. One is you can name those individual families and friends, but if you don't have anyone to fill that role, then, well, guess what? A private professional fiduciary, an individual who is licensed by the state of California, is bonded with the state to step in and manage these assets, like our Peter Kote, for instance.
There's about 60 private professionals here in Orange County, and we're going to go through all of that in detail. But one of the things that find people are confusing about, why do trusts have to be 50 pages and and do the powers that are reiterated in the document, why are they there?
Yeah, great question. And we could only be so lucky if the trusts were just 50 pages. They're closer to 80 or 90 pages now, Pete. The answer is that you want to be able to show third parties with whom you're dealing a set of rules that tells them that what I, the trustee, am doing right now, I have the authority to do those things under the terms of the trust.
And they have to be enumerated in the trust?
Well, so again, there's a whole set of laws that are out there under the California Probate Code that enumerate a number of things, okay? Some of those things you can modify by the terms of your trust. For instance, we talked about this prudent investment rule, right? Prudent investment means we're going to diversify our assets. What happens if you own a closely held business and you don't want the trustee to sell that off and invest in other stocks? You can actually set those rules in your trust document to say, I'm waiving that prudent investment rule as it pertains to this particular asset. So that list of rules becomes very important to the extent that your trustee wants to take certain actions in the future for your benefit.
Explain what the difference is between normal liability and fiduciary liability.
Right. So a normal, well, let's talk about what a fiduciary liability is. A fiduciary liability springs from a fiduciary duty. And that means that someone is taking on the role to oversee your trust, and we've invested in them certain trust and power to do these things. And the law says that if you're going to undertake those responsibilities, you have an obligation to always put the beneficiary first, okay? That means every decision that you make, you need to do it in mind of how can I benefit the beneficiary, the person who ultimately is receiving those assets. A normal obligation may be, I have a contractual obligation. Well, we each can contract to do certain things. I may enter into a contract to perform certain services. That doesn't necessarily raise it or elevate it to the level of a fiduciary obligation. In a regular obligation, I can look out for my own best interests. In a fiduciary obligation, I'm required to look out for your best interests.
So it's the highest level of liability under the law here in the United States.
Correct.
And then does that apply even to a family member or to a friend or a trust company or a private professional?
Yeah, it applies to anybody who accepts that role to serve as the trustee of the trust.
Okay. And then you can, next thing is who can be the trustee? We kind of already mentioned that, but should you name a friend or a family member? You are meeting with families all the time. How much energy gets put into who's going to be the successor?
I would say that when we have a discussion and we talk through an entire estate plan and I tell them these are the open items for you to consider and come back to me to finalize the estate plan, it's not questions as to, hey, what kind of trust should we choose? It's always, gosh, who do I name as the successor trustee? Who should step in and do this when I'm gone? You know, a question that I typically get is, I've got 2 children. Should I name co-trustees? I really don't want to offend one of them by not naming both of them, right? And the answer is, a true lawyer answer, it depends. It depends on your family. It depends on what your objectives are. If you were asking me and I had my druthers, I would say based on conflicts that we see that pop up in the trust administration area, that you're sometimes better off naming just one person to serve as a successor trustee as opposed to co-trustees, so you don't have this deadlock that you may have to go to court to fight about.
Okay. If you name, let's say, your oldest son to be your successor trustee, and something happens to the parent, and the older son has to move to Nebraska, and can the son that moved to Nebraska appoint a successor, or would that work?
Yeah, it's going to depend on the trust language. So the first thing to understand is that generally speaking, when you name a successor, we're going to actually ask you to name a list of successors. If not, we're going to name son first, and if not him, then this individual, and if not him, then this individual, so that we have a clear line of succession, okay, first of all. But many trusts, and for instance, we often will draft these types of trusts, will say that that son who's living out of state, upon his resignation, he has the ability to appoint a successor to step in and serve. And in the absence of that appointment, then we go to the next person in the list.
Okay. And if they want to appoint a successor, it needs to be stated as such that they have the power to do so in
Correct.
the trust.
Because generally speaking, unless the trust says that a then currently serving trustee has the ability to appoint his or her successor, the law doesn't allow them generally the ability to do that.
We're seeing more and more today about having a trust protector in the trust. Could you spend a couple of minutes on what that is and when you recommend one?
Well, you know, Pete, that's not one of my slides, but
I know.
No, I'm actually a huge proponent of a trust protector. So remember, it's two different hats. So the trustee, her or his role is to, one, manage the assets for the benefit of the beneficiary, to make decisions then as to distributions or the use of those funds for the beneficiary. What happens if you name a private professional fiduciary or you name a trust company? And what happens if in the future that individual or that company isn't doing a really good job? You know, what happens if they start gouging you on fees or they make really poor investment decisions? You know, what ability do the beneficiaries then have to step in and remove that trustee or to replace? Well, in many cases, the answer is you have to go to court to actually get someone, a court to remove that trust company or that private fiduciary and to appoint a successor. In our documents, we recommend a trust protector. Now, his or her role is totally different. They sit on the sidelines and they watch the trustee to make sure that he or she or it is doing their job properly. They get regular reports so they can see the financials, to see how the investments are doing, to see what distributions are being made. And then to the extent that the trustee isn't doing their job, the trust protector can step in and say, this is your warning, here's a letter, this is what you need to do. And if you don't do it, then I, the trust protector, have the authority to yank you out and to put a new trustee in your place. And we get to skip the whole court process. We can do that simply in the trust document. There are other reasons that we would maybe do that also, to move the trust administration out of state, and those are kind of beyond the scope of what we're talking about, but it's a vital and important role in our trust documents.
Let's go to the next slide.
You got it. All right, so we've talked about the settlor, we've talked about the trustee, let's talk about the beneficiary. That's the person who gets to receive the trust property. And again, as I mentioned before, when you set up your trust, you're the trustee, you're the settlor, you're the trustee, you're the beneficiary. So you get the benefit of all of those assets in the trust. But then ultimately, once you've passed on, the beneficiary is the person that you name to receive your assets after you pass away. So that can be an outright distribution. You know, here you go, here's 1/3 of all the trust assets, here's a check for the bank account, go your own way. Or maybe you decide that it makes sense to let that beneficiary receive his or her share in a lifetime benefit trust, which we'll be talking about in a little bit more detail today. Okay, so one quick question I got here. You know, if I'm a person, a young adult, single, no real estate, substantial balance in a 401k and savings in a beneficiary, you know, do I need a will or do I need a trust? And again, this is kind of going back to what we're talking about before. I think the answer there is you still need a trust for all the probate avoidance purposes that we're talking about. And I think you still need a trust that you can decide how you want those beneficiaries to receive those assets after you pass away. All right, let's move on here. So let's talk about the phases of the trust. So you've been in to see your attorney, you've set up the trust document, and you say, well, now what? So there are 3 different phases to the trust. One is during your capacity, okay? That's the simple one, and we'll talk about that in just a minute here, what that means. Then we draw a line in the sand when you are declared incapacitated, okay? Maybe that's dementia. Maybe that's a situation where the doctors have said for a health condition, you're not able to manage your own affairs. Maybe, quite frankly, it's you get to a certain point in time in your life where you're old enough and you say, I don't want to deal with this anymore. I just want to turn over the keys to someone else and let them administer it for me, right? To one of my kids. That happens all the time. And then the third phase is what happens after you pass away. So let's jump into each of those phases. Okay, so again, during your health, during your life, you have the ability to do anything and everything that you want. These trusts are set up as revocable trusts, which means that you have the ability to amend it, to change it, to revoke it, to tear it up, to do anything you want. It's your assets, okay? Similarly, you can put assets in, you can pull assets out, you can make gifts, you can sell property, you can buy property. So no day-to-day changes. And in fact, these trusts are even disregarded for income tax purposes, which means even if you own a business and you hold it in your trust, if it's while you're alive and healthy, then you don't even file a separate tax return for that trust. Instead, it just all flows through to your personal income tax return. All right, well, then what happens?
Give your own social security number.
Exactly. And that's a question we get all the time, by the way, Pete, which is, I've just set up a trust and now I'm trying to set up a bank account, or I'm trying to do this. What is the employer identification number for my trust? And the answer is you don't have one, because you don't need one. You can just use your social security number. And if it's a husband and wife scenario, or husband, wife, you can pick one of the two of you to use as your social security number, to use as the identifying number for that trust. Okay, so again, if you step in, if there's a situation where you're determined to be incapacitated. So let's just take a quick minute and talk about what does that mean? And that's going to depend on the language in your trust document. How do we determine incapacity? And generally speaking, it's going to revolve around one or more letters from your medical professionals, your treating physician, saying that he or she, because of an underlying medical condition, lacks the ability to manage their own financial affairs.
Would recommend today one medical doctor versus two. Many of your older documents have two. Today, it's just more difficult to get two different doctors to declare that you have incapacity.
Yeah, I guess I'm just a little bit of an old timer in this, Pete. I still like to.
Okay.
The reason being is that we've seen situations where family members will show up and they'll have one, it'll be the child of our client, and they'll have a letter from a doctor saying mom is incapacitated. And then we have another doctor who's out there that's meeting with mom saying, no, she's still got it together. And so it's a little challenging if we're just down to one letter, but it's certainly workable. I still like to go with the two letters.
Okay.
Okay. So again, once you are determined to be incapacitated, or you resign, right? You just step away and give the keys to the kids or the successor trustee or whoever to take over. Then that starts the second period that we're talking about. And again, your trustee has an obligation to step in, manage those assets for your benefit, to make distributions of those assets as dictated in accordance with the trust, okay? And then ultimately to manage those affairs broadly. Now, Pete, I know you had some questions or some comments there.
No, I was just going to mention that, family members sometimes when they step in think they are the owner, they're the grantor, and they can't treat this property like their own, like it's theirs.
Absolutely not. And in fact, you have an obligation to account to the trust beneficiary as to your use of those funds. Now, and Pete can probably speak to this because he does these accountings on a regular basis. But in general, what we're talking about here is that you have to be able to prove to outside parties that you are using those assets for the benefit of the beneficiary of the trust.
Yeah.
And so, the issues that we see coming up all the time, charging crazy fees. We see this, pulling money out to, saying, mom, let me use this money, or she gave it to me. I mean, those are issues that we see come up all the time.
Yeah.
And so,
let's go to the next slide and talk a little bit more about this trust administration.
You got it. All right. So then when you or your spouse passes away, then there's some certain obligations that we have to do. Okay. The first thing that we need to do is we need to look at the trust and see what the trust tells us that we're supposed to do. And we're going to talk about in just a minute here the difference between, you know, a single person trust and a married family trust. But in general, you got to follow those trust terms. You got to go out and take stock of all of the assets. That's called marshaling the assets, to make sure that you know what's held in the trust. And you do that for a couple of reasons. One is you want to make sure that something didn't get missed, that you have an asset that's hanging out there that should have been titled in the trust that isn't. And now we've got this question, are we back to having to do a probate of that asset to get it into the trust? So that's marshaling the trust assets. Then both the trust and the California Probate Code impose a fair number of obligations on behalf of the trustees to give notices, for instance, to people to tell them about the death of this settlor and the death of this beneficiary, to tell them these are the terms of the trust. And in general, under Probate Code 16061.7, you know, you've got to give a copy of the trust to everybody who's named in the trust document as a beneficiary. You also have to give a copy of that trust to every heir at law. And so that's a term that means essentially, if you have children, then each of your children is going to be receiving a copy of that trust. That can kind of be a little bit difficult sometimes if you've chosen to not give anything to that child, right? So keep in mind that when you make those decisions as to who gets what under the terms of the trust, that ultimately, you know, all of your heirs at law, your children, will each be entitled to a copy of that trust document.
And how long, what kind of notice is that?
So you're required to give a notice under 16061.7. Once you give that notice, then the beneficiary who's on the receiving end, or the heir who's on the receiving end of that notice, has 120 days to step in and challenge the trust. Mom didn't have the capacity, somebody forced her to do this, you know, whatever the case may be. And if they don't respond or file something to contest that trust within 120 days, then they're forestalled. They cannot make any challenges to that trust in the future.
But that 120-day notice, can just the trustee, successor trustee, do that on their own, or should they hire an attorney to do so? I'm giving you a softball question.
The answer is you should always hire an attorney.
Exactly.
I say that, and I say that tongue in cheek, but truthfully, you know, most people who don't work in this area, they aren't familiar with all the rules.
I work in this area. We always hire an attorney to do those notices. They're absolutely important to do.
Right. And there's things about lodging the will. There's all of these kinds of administrative requirements that the normal Joe or Jane wouldn't have any idea about.
Yeah. And it does take some time. So, you know, living trust, you don't, when somebody dies, the funds aren't distributed the next day. It's the administration process is anywhere from 6 months to 11 months.
Sure. That's right. And part of that in large part is because of taxes, right? And there are a lot of things that we have to talk about with taxes, and we'll talk about those as we kind of go forward. But there's filing a final income tax return for the decedent. There's finding out what the value of all those assets are in order to determine, do we have a problem from an estate tax perspective, the federal estate tax. And so all of those things take time. And most of those things are not items or issues that a normal individual would be familiar with.
Yeah, and the probate code still rules, even though you have a living trust. Let's go into the types of trusts that we have.
You got it. Okay, so let's talk about the simplest example here. This is a single individual, okay? She, in this case, sets up her trust. She creates that box. She puts the assets into that box. And then when she is incapacitated, then the successor trustee, the manager, is going to come in and manage those assets for her benefit. When she passes away, the trustee is going to do all of those things that he or she is required to do by law and by the trust document. And then ultimately, those assets are going to be distributed to the trust beneficiaries. All right, who can you name as a beneficiary? Well, family members, favorite charity. I got one question: if I don't have any kids, can I leave everything to my nieces and nephews? Absolutely. Okay. It's your money. You can give it to whomever you want to receive those assets. This is
and Blaine, if Are heirs due a copy of the trust, even though they've been omitted from the trust?
Yes. Yes. So an heir at law, again, the example that I gave, if you have a single individual and she has 3 children and she decides to give everything to 2 of the 3 children and to specifically omit that 3rd child, under the law, that 3rd child who was omitted is an heir. Okay, and that's a legal defined term under the statutes, or it's a descendant of our individual here. They are entitled to a copy of the trust, and they're going to see that they were omitted. And that gives them then the ability to step in and challenge, to say, mom would never have done this. Mom didn't know what she was doing, and to, raise that legal challenge.
Blaine, then is it important in writing the trust that they explicitly exclude the child, name them and exclude them, rather than simply not mentioning them?
Yes, absolutely. I think that's vitally important. From a practical standpoint, what I also do is I also counsel many of my clients to give them something. It doesn't have to be as much as everyone else, but give them something. Why do you do that? If you're going to give them $25,000, you're also going to include a provision in your trust called a no contest clause that says, if you challenge this, you lose everything. So if you give them just a little bit under the terms of that trust, that may be enough of an incentive for them to not challenge the trust as a whole.
$1 will not do it.
Yeah, $1 is not going to do it. I mean, and again, it's not a legal issue. That's more just a practical issue. It's got to be enough for the person to feel like I don't want to give this up on the chance.
Yes. And remember, on the living trust for a single person, and all of us are going to be single at some time, most of us anyway, it's the whole incapacity is the issue there. That's right. Okay, let's go to the next slide.
Okay. Now, I'm not going to go into a lot of details here, but there are all kinds of trusts to choose from. Okay. There's the very simple trust. I call it the I love you trust, and I illustrate, I think, let's see, I'm jumping ahead here, but the I love you trust is essentially husband and wife. When the first one passes away, you don't have to do anything. Everything goes to the surviving spouse. He or she is the survivor. I call it the winner take all approach. They can amend, they can change, they can do anything. Under some of these other variables, the AB trust, the ABC trust.
When was the AB trust? Almost every attorney did an AB trust. Yeah. I think it was maybe 10 years ago. Mm-hmm. If you have an AB trust, what should a consumer be looking at today?
Yeah, that's a great question. Now that's going to get really deep into tax issues here.
Just get the highlights.
Yeah. So in general, I'm still a big proponent, by the way, of a trust that splits, whether it be an AB trust, an ABC, or an AC. And we'll talk about why one may be better than the other. But in general, it used to be the law that on the first death, if you didn't use the deceased spouse's estate tax exemption, that you lost it. It was a use it or lose it. And so we would split into 2 separate trusts in order to ensure that we used his exemption. So then we had her exemption left over in the A trust when she passed away.
So that you did it for tax reasons.
For tax reasons. Now the tax law has changed. And if you want to write down a note, you can Google this. It's a concept called portability, Portabil, portability, right? Portability. And that came into law temporarily in 2010, and then it was phased in permanently in 11 and 12. And what that says is we no longer have to necessarily split the trust for estate tax purposes. Instead, we can transfer all of the unused exemption over to the survivor, and she can use all of her exemption and all of husband's exemption, and everyone's happy. So when I have clients who come in and they have a trust that's been designed prior to 2010, I know it's going to be an AB or it's going to be an ABC trust. For various estate and income tax planning reasons, that may not be the best choice right now. There may be another choice that maybe you want to look at the no split trust, or maybe you want to look at an AC trust. And again, that kind of goes beyond the scope of our presentation, but that's something you want to talk to your lawyer about.
Yeah. So just The AB trust was done for tax purposes. So if somebody has an estate, a married couple today, under what you should say amount.
Yeah. So
Uh,
so if they have an estate under $23 million.
Okay. So they don't, so they should be looking at maybe an AC trust
Yeah.
and do an AB trust possibly for family issues.
Perhaps. That's right.
Okay.
That's right.
So what's a disclaimer trust?
Well, where again, it's going a little bit beyond the scope, but you know, the disclaimer trust essentially is we're going to leave everything to one person and give them the ability to disclaim a portion down to a subtrust, or really even to pass it along directly to the heirs at the first death. And sometimes that makes sense. And you'll often see that coupled with that no split or just the A trust.
In fact, let's go to the next slide. You're going to talk a little bit about why.
You got it. All right. So here are some of the things. So we were hinting at some estate taxes, and I'm going to talk about that in a slide just a minute. There's this concept of community versus separate property assets. From a very high level, a community property asset, if you live here in California, we're a community property state. When you earn something during marriage, it is presumed to be a community property asset. If you receive something by way of inheritance, or you brought assets with you into the marriage, then that's a separate property asset. And depending on what the makeup of those assets are, we may decide to go with one trust over another. Another concept here I'm going to talk about in more detail, blended families. And then finally, some asset protection. So let's jump right into those. And again, talk to a lawyer who can tell you which one makes sense. All right, so here is just kind of a snapshot of what the estate tax exemption has been over the years. This is what we're talking about. When you pass away, the IRS is going to take a snapshot of the sum total of all of the assets that you own at the time of your death. And if the aggregate value of all of those assets is worth less than the estate tax exemption, then your estate doesn't pay any taxes whatsoever. The current law is if it's over the estate tax exemption, then for every dollar over that exemption amount, you're going to pay tax at the rate of 40 cents on the dollar. Okay, so let's talk about what that means. So 2001, it was $675,000. So again, if you had $1 million, you'd back out the first 675, and the 225 would then be subject to taxes. Right now in 2020, that amount is $11,580,000 per person, plus cost of living adjustments. That's what the COLA means. That amount is going to inch up as the current law is worded all the way until January 1st, 2026. So without any congressional or presidential action, on January 1st, 2026, that number is going to drop back down to $5 million, or the value that it was before these tax changes went into effect, increased for inflation, which again, we all agree will probably be around $6 million per person. Okay, so you can see how this number is kind of going up and down. And then of course, depending on who wins the election in a few weeks here, Joe Biden has proposed going back to the tax law that was in effect under the Obama-Biden era, which would be a $5 million exemption per person, which means as a married couple, you can shelter $10 million of assets. So just,
Blaine, let's say, for example, I have $100 million estate.
yes.
I've got at least 20 good years to live.
Mm-hmm.
Can you, with your smart background, your taxation, your legal background, get my estate to zero? So I don't have to, my estate, not my heirs, my estate pays zero taxes?
The short answer is a definite maybe, and it depends on how charitably inclined you are. And I'm going to kick that to Dawn, who's going to be handling that, I think, next week to talk about those issues. But yeah, there are a lot of tools that we can do. I'll just throw this out, which is, given the inevitability of a change in that exemption amount, if you find yourself over 10 or 11 or 12 million dollars, then now is maybe a good time in the next couple months to think about making some gifts while we have that exemption amount. So talk to your lawyer quickly. You've got kind of a short window to step in and perhaps make those gifts.
Yeah, but the estate tax area is almost a voluntary tax if you don't do any planning, is my point.
That's right.
You know?
That's a great way to say it. It is a voluntary tax because if you don't do the planning, you will, or your estate will be paying those taxes. It's
Okay, let's go to
inevitable.
the next slide.
All right. Okay, so let's talk then about what I called the I love you, the no split trust. So I talked about it generally here, but it's a joint trust on the death of the first spouse to die. Nothing happens. The surviving spouse then has the ability to step in and manage that trust, to amend and restate and totally change that trust. And then ultimately in the end, when she has passed on, then those assets are going to pass to whoever the beneficiaries are that are named in the trust. That's a very simple way to do it. And some of my clients, that makes a lot of sense. You know, if you've been married for 65 years and you're in your late 80s, early 90s, maybe this is a good choice because we don't have to do it for tax purposes. But
yeah, and you want to keep things as simple as possible.
Sure. But there are some kind of risks there. So
Yeah.
let's just kind of give a quick illustration here as to how one of these A, B, C trusts work. And it's a similar concept for an AB trust or an ABC. But, you know, in theory here, on the death of the first spouse, then what's going to happen is the surviving spouse's share, all of her separate property and her share of the community property is going to come over there and it's going to drop into that survivor's trust. Okay. The deceased spouse's share is going to go over to the other side of the equation, either the B or the C or some combination of the two. What's important to remember here is that the survivor has the ability to get all of the income from that B or C trust. Okay. It's no questions asked. But when it comes to the principal of those assets, the actual investments, the survivor gets to dip into those only for her health, education, maintenance, and support. Okay, so health and education, I think probably makes sense. Support is kind of the baseline, which is whatever's necessary to literally survive, right? Food, housing, whatever. Maintenance, though, is where we're talking about to maintain the standard of living to which the surviving spouse is accustomed. So, you know, if you were going on vacations once a year to Europe, you can continue to use those funds to go on vacations once a year to Europe. I had a client who liked to buy a brand new Mercedes every year. So we told her, you can continue to buy a brand new Mercedes every year, right? That's maintaining the standard of living. The surviving spouse portion, that survivor's trust, again, she has the ability to do anything she wants with that. She can give it away. She can invest it. She can live frugally, whatever she wants. That's entirely her assets.
How would the bypass trust be titled? After death, what would a title look like?
Yeah, that's a great point. So going back here, when we split these assets between the two different trusts or the three different trusts, it requires us to actually allocate those assets. So we're going to enter into an allocation agreement that says, I, kind of schizophrenic, I, the trustee, agree with I, the beneficiary, and I'm going to put these assets over into the survivor's trust and these over into the bypass trust. Then you actually have to transfer title. So that means going into the bank and telling them, and generally what it would be like Blaine Searle, trustee of the Searle family trust, dash bypass trust, or dash marital trust, or dash survivors trust. That's generally how you would title it. But if you're talking about real estate that you're going to be putting into those assets, you actually have to record a deed to transfer the title into those trusts.
Yeah. Please see an attorney and a CPA upon death. This is not an easy decision to make as to what property goes into what trust.
That's right. That's right. Ultimately, then what will happen is if the survivor doesn't do anything to change the survivor's trust, and remember, the survivor cannot change any of the terms of the bypass trust or the marital trust. So
you're locked in.
You're locked in. And if you say, I want it to go to these beneficiaries, it's going to go to those beneficiaries. Okay. I'm dealing with a situation right now. I've got a client who has an AB trust and it says it's going to go to these three individuals. Unfortunately, one of the children is subject to a disability. And we can't go in and put a special needs trust in for that under the bypass or marital unless we get some court approval, because we don't have the ability to amend that trust.
Yeah, I get a lot of times one of the kids say, hey, mom told me I could do blah, blah, blah.
Yeah.
I'd say, show me where it is written in the trust and I can do it. It's not my money. I'm acting only as the trustee.
That's right.
It has to be in that document.
Yeah, that's right. That's right. Survivor can change the survivor's trust if she wants to, right? That's fully up for grabs. Then ultimately what's going to happen, those assets are going to all combine together, and then ultimately they're going to go out to the beneficiary. So let's spend a couple minutes here and talk about why we would want to do this ABC trust, situations in which it makes sense. So the first that we've been talking about is estate taxes, okay? There may be a good reason. Now, once we pass that portability that we talked about before, there's less of a reason to actually split up the assets for estate tax purposes. But maybe we want to do it because we've got a blended family. You know, we've got his, hers, and ours together, right? And one person brings assets in, another person brings her own assets in. And I want to make sure that I'm able to take care of my children from a previous marriage in case something happens to me. Okay, we see this all the time. And if we leave it in that no split trust where everything is up for grabs, guess what? The surviving spouse has the right to cross that box out, create a new document, and give everything to her children if she wants to, or his children, okay? So if we've got a blended family, maybe that AB or that AC trust makes a lot of sense. Maybe we're not concerned about the kids being disinherited. Maybe we're concerned about protecting our spouse from the kids, right? We want to make sure that we're providing for our spouse to make sure that he is protected and has the cash flow that he needs and the right to stay in the house and all of those things. And again, we may need to do that through an AB or an ABC trust. And then maybe we want to put some special safeguards in place to make sure that when that second spouse passes away, that we're going to have a smooth transition, right? What does that mean? Well, I drafted a trust recently where we had a his and hers. And what we ended up doing is saying that after both of them had passed away, that one child from each of the families were going to serve as co-trustees together to make sure that everything was administered properly and everything was done fairly, right? So this is one of the considerations I think that would be important if you've got a blended family. All right, let's talk about asset protection. Potential threats. Let me just give you a couple of examples here. We had a client, husband and wife. Husband dies suddenly. The wife is at the funeral home and makes all the funeral arrangements, driving home, not paying attention, barrels through a red light and plows right into a car, T-bones them in an intersection, and comes to us and says, I'm going to get sued. What do I do? Well, if she had a no split trust where everything was in that box, we knew that 100% of the assets would be up for grabs, that the creditors could come after those. But because we knew that her and her husband had an AB trust, we knew that 50% of the assets would be protected from creditors, those assets that went into the bypass trust, because the wife didn't own those assets. She only had the right to income and principal according to those standards. So we knew that at least the assets in the bypass trust would be protected. And again, to rephrase that, if she only had a no split, what I call the I love you trust, then 100% of those assets would have been up for grabs. So this applies to, car accidents. It applies to the IRS coming knocking, any lawsuit that you can imagine, we get some protection there. So we've talked about creditors. Let's talk about predators. There's something about our mind as we get older that we lose some of the inhibitions that we previously had. Some of the things that say, don't do this, right? At least once a year, we get somebody who comes into our office who says, I want to give everything to this person right here, my new boyfriend, who's 45 years younger than I am. Tell me about your boyfriend. He's my live-in nurse. That's how we met. Okay. Now, spoiler alert, that's not allowed, right? There are special rules that come in when we're dealing with giving a gift or a bequest to someone who's a live-in nurse, but it happens all the time. If we have a no split trust, then in theory, that surviving spouse could give 100% of those assets to the new friend, to the televangelist, right? To whomever, and we have no protection from the children. So some of my clients like to say, Maybe if we split it into the A and the B or the A and C trust, we know that at least half of those assets are going to be protected from the kids, even if you decide to give those other assets to somebody else.
Can you, let's say you want to protect your assets for yourself.
Right.
Can you create a living trust, and will that protect you from any kind of creditors? Can you do that for your own self?
That's a great question, Pete, and it's one that we get quite frequently. The answer is that these trusts that we're talking about, the A trust, the no split, AB, ABC, they don't provide creditor protection while both of you are living, okay? Essentially, if you get sued and you and your spouse have this ABC trust, all of your assets are going to be up for grabs, okay? The only time that we get some of those protections is once one of the trusts becomes irrevocable. So I get a question all the time. Well, can I set up a trust that's an irrevocable trust from the very get-go, and I'm going to give all of my assets to the trust, and I'm going to be the beneficiary? So if somebody sues me, I'm protected. That's in California what we call a self-settled trust. And California doesn't recognize self-settled trusts for asset protection purposes. There are other states in these United States that do respect those, Nevada, Delaware, and some other places. And so in some cases that makes sense for us to go to those other states and create some of those trusts. But here in California, you cannot create a trust that's bulletproof from asset protection. All right, so let's talk then. Let's assume that we've got this ABC trust. Everything is combined back together. It's now all being distributed out, and we're going to different individuals, okay? So now is the question, how do we get it out of the trust? You know, to whom should we be giving it? Well, first of all, we've talked about charities, and you can designate charities in your trust. We've talked about nieces and nephews. Absolutely, you can give those gifts. A question that I get all the time, can I give certain gifts to my grandchildren? And the answer is yes, you can do that. We see that in trust all the time. But then ultimately, we've got these beneficiaries, and 9 times out of 10, it's, I want it to go to my children. Well, that's wonderful. What happens if tragically mom and dad pass away when their children are still minors? If the assets are going out to the children outright and free of trust, then if they're a minor, then technically speaking, we've got to go to court now and get someone appointed to be the guardian of the estate of that individual to take custody of those assets until that person reaches the age of 18. So it's not ideal. So we have standard language in our trust that says if anybody's going to get a distribution from the trust, we actually use the age 25. If they're under the age of 25, trustee hold those assets in trust and use them for their benefit. Then when they hit 25, they can have their share.
I'm
Okay,
beginning to believe that it has to be 55.
Yeah, that's absolutely right. I don't disagree. My clients ask me all the time, what's the right age? And I say, I'm 44 and I'm not sure that I'm responsible enough to manage my own assets, let alone anybody else's.
Yeah. And what do you recommend that that parents split it up? In other words, give a bite at the apple with a certain amount and then more a little later on?
I actually don't. And
really? Okay.
Here's why. Because I'm a big proponent of instead giving it to the children as a lifetime benefit trust.
Okay.
So if we flow that down to the children and we create new boxes, if you will, a new trust, right? Now the child is the beneficiary of his or her own trust. And in fact, we're going to jump right here. We're going to talk about this. Each of the children can get the income, and the trustee would use those assets for the principal of those trust assets for, again, the beneficiary's health, education, maintenance, and support. Guess what? If that child gets divorced, okay, happens, here in Orange County, we've got a better divorce rate than the national average. If they get divorced and they've received that inheritance outright, then there's a question. Did we commingle it? Did we somehow lose the separate nature of that asset, right? But if we keep it in this box, then there's no question that inheritance is not part of the marital estate to be divvied up or divided up upon divorce.
So a lifetime trust would give you spousal protection in the event of a divorce.
Correct.
Okay.
It gives protection in the event that the IRS comes knocking, right? Then I get the question inevitably, but Blaine, I don't want to control my kids from beyond the grave, right? I will tell you, by the way, I have a good number of clients who are perfectly content to continue to control their kids from beyond the grave. But in any event, some of our trusts are set up in order to allow the child at a certain age to step in and serve as a co-trustee with the then serving trustee of the trust, kind of give them some time and ability to get used to managing the trust assets.
And then they could serve as their own trustee.
Exactly, at a later specified age. That's right.
So, and literally they could treat the money almost like it's their own.
They can. And here's
should do so, but
Yeah, that's right. In other words, your children, the children who are the trustees and the beneficiaries of those trusts, they are the ones who are making the decisions. Does this expenditure account for health, education, maintenance, and support, right? And
Blaine, do you recommend a minimum amount? In other words, should a person least fund these trusts with $300,000 to $500,000, or would you go as low as $100,000, or what's?
It's a great question. And the reason that you have to think about is that these trusts, remember, they're going to be filing tax returns every year. There's some administrative fees that are associated with these trusts. So it's not just a simple decision, yes, no brainer, goes into the trust. Yeah, I mean, I think you probably want to look at those numbers. If you're looking at less than $100,000, then it's really up to the client to weigh it. Does it make sense to keep it in this box?
I usually recommend practicality, unless there's another reason, 500,000, $300,000 to 500,000 minimum.
Sure.
And talk a little bit about spendthrift. The spendthrift, what kind of protection it gives.
Right. Well, so in this thought here, the concern with the spendthrift trust is to make sure that they don't squander their assets, right? When you are going to be combining, setting up this trust where you've got the child who's the trustee and the child who's the beneficiary, remember that we talked about that other hat that people can put on, which is the trust protector. And this is a great time for the trust protector to sit in the wings to make sure that the beneficiary and the trustee are using those assets for their best benefit, and they're not squandering those assets. And again, to the extent that they do squander those assets, then you've got the trust protector who can step in and yank them out and put in, a Peter Kote, a private fiduciary, a trust company to fill that role to essentially protect these kids from themselves. These trusts are great, though, in the sense that it provides the ability for your children to, if they want to start a business, they don't have to pull the money out of the trust. They can start the business with the trustee of this box owning the business, right? So there's a lot of different things that you can do to allow these to grow and to really pass this on. And ultimately, when those children die, the way that most of our trusts are set up is that they will pass in cascading trust down to their children or your grandchildren, in other words.
Blaine, when you do these trusts and you read these trusts, will it say I'm forming an A trust, I'm forming a B trust, I'm forming a spendthrift trust? Does a client need to know and remember all these different names?
Yeah, it's pretty rare for a trust to call something an A trust or a B trust or a C trust. They're going to use other names, right? Survivor's trust is the most typical. For the B trust, it's sometimes called a bypass trust or a decedent's trust or a credit shelter trust. The C trust is sometimes referred to as a marital trust or a Q-tip trust, and that stands for a qualified terminable interest property trust. So there are all of these terms of art that can sometimes make it a little bit challenging for someone who's not familiar with how these are written.
And attorneys use different terms for different
they do
trusts.
Right.
So if you're confused on trust names, don't worry about it.
You're in good company. That's right.
Yeah, just remember, you can protect an individual from themselves. Mm-hmm. You can protect from creditors. You can protect somebody from a spouse, what we call the outlaw versus the in-law.
That's right.
So how about special needs? Are we going to cover that?
Where I was going. That's right. So down here, we've got this picture here of someone with some type of a disability. Now, obviously, physical disabilities are not usually what we're getting at, but for someone who has some type of limitation or disability, such as that they would qualify for Social Security disability, right? These are things like,
I have an individual who was brain injured,
yes.
and she's now collecting Medicare, Medi-Cal, and the only reason why she's able to take advantage of the government benefits is because mom and dad put her monies into a special needs trust.
Exactly. So these benefits that Pete is talking about are needs-based benefits. In other words, they're going to look at a snapshot of the value of all the assets that person with a disability has in his or her name, bank accounts, property, and so forth. And if that sum total is too large, it could disqualify them from receiving those government benefits. So we have to be careful, because if mom and dad pass away and we go outright to our 3 kids in equal shares, well, we've got a problem, because now this child who has a disability is just receiving a giant lump sum. It could disqualify them from receipt of those future benefits on a go-forward basis.
And it's not just the money, it's that they can't take advantage of those benefits.
Right, that's exactly right. That's right. And so the idea here is to, instead of giving it to them outright, we're going to put it in a box, and we're going to call it this special needs trust, right? And the hope would be then the trustee is going to use those assets to supplement rather than supplant or take the place of the government benefits. So the government is going to pay for X. Well, the special needs trust is going to come in and pay for Y. We're going to use some money to pay for a trip for them, to buy a computer, to give them some entertainment expenses, things like that, that would not otherwise disqualify them from receipt of those government needs-based programs.
So you, as the attorney, really need to understand the family.
Mm-hmm.
Well,
Very much so.
Who's doing what? How's the marriage doing? How's the health of the kids? How responsible are they as far as money management is concerned? What's the dialogue between the children? If you're going to name one of them as the trustee, who's the mediator?
Do we have any history of substance abuse? Right.
Oh, huge.
Right. It's huge.
Oh, it's just dramatic today.
Right. And so we can address all of those things. We have a pretty standard provision that we put into our trust that says, to the extent that a beneficiary has a substance abuse issue, 1, he or she can't serve as the trustee of their own trust. And 2, the trustee, while he or she may be managing those assets, they're not going to make distributions to that beneficiary where the beneficiary is going to turn right around and use that for some illicit substance. Instead, the trustee is going to hold those back and use those funds for drug treatment programs and so forth.
Yeah.
And so they've demonstrated that they've reached a level of sobriety that they're comfortable to start giving them money again.
Yeah, and this is one of the reasons why you don't want to go to a trust mill. Yeah. This is one of the reasons why you don't want to go to an attorney who just does wills and trust on the side. This is one of the reasons why it takes time to draft a proper trust, and you don't want to do this yourself because you're not familiar with all the different languages that need to be included in a trust document.
Right. Now, I will tell you that I get questions all the time. What do I think about LegalZoom? And it's a great company, right? I think for forming entities, it probably does just fine. I will tell you, my answer always is that LegalZoom is one of the best benefactors for our trust litigation department, because those trusts are not addressing all of these issues that Pete is talking about. And they can't, because you have to have an interview with your attorney to talk through, to ask these questions, to share these comments in order to make sure that the document meets your objectives.
And avoid going to paralegals as well.
Yeah, I mean, paralegals are great, but again, it's this issue that we're talking about. And we sometimes see trusts come into us that say, and after we both pass on, the beneficiaries of the trust are, and it's blank, right? I mean, those are the kinds of problems that you see pop up sometimes with with some of these trust mills.
Yeah, and there was a question regarding who gets a copy of the trust. Everybody who is named in the document. So alternate beneficiaries, charities. We had a situation where an individual listed, I want my A friends to get 50,000. I want my B friends to get 25,000. And I want my C friends to get 10,000. And she came up after the workshop and said, are all these people that I've named A, B, and C, will they see a copy of the trust? And the answer is
yes.
Yeah,
They will.
Absolutely.
Yeah.
So,
and not only that, but to take a step further, let's assume you have a trust document where you disinherit someone, and then you have a First Amendment to the trust where you bring them back in. Okay. When someone gets a copy of the trust, that means the original document and the First Amendment, which means that they're going to see the evolution of what happened through that process. And so if that evolution is divulging information that you're not comfortable with, then we need to amend and restate, just ditch the whole
talk
thing.
a little bit.
The fresh document.
What does it mean to restate a living trust?
Yeah. So you set up your trust document, you put that box in, and you spend all of that effort getting everything titled in the name of the trust. The Searle Family Trust dated October 13th, 2020. And that whole thing is named in the title of the trust, okay? And now I decide that I want to start fresh and I want to ditch the whole thing and I want to move forward with a new document. I have the ability, as long as everyone's alive and healthy, I have the ability, or my spouse and I have the ability to step in and we get to amend, which means to change it, but for purposes of clarity, completely restate. So we're starting with a fresh document that has all of the terms that we like in it. The only similarity that it bears to the starting document is the name and the date. So
Okay.
we keep that original name and date so we don't have to go through and retitle everything.
And a lot of
time we
times
amend the trust.
it's less expensive just to restate the trust instead of making, and sometimes when you get over 5 amendments,
Yeah.
it's very difficult to understand and follow all the logic that went into it.
That's right.
Okay. There was another question regarding, let's see, can beneficiaries tap into the C and the B trust while the surviving spouse is alive?
If by beneficiary we mean the surviving spouse,
No, we're talking about the children.
right? No, the answer is no. Unless the surviving spouse has somehow disclaimed a portion. A disclaimer is something that happens when an asset is supposed to flow to an individual under the terms of the trust. They have 9 months from the date of death to say, no, thank you, I don't want any part of this. And for that portion of the trust, the IRS treats it as if they predeceased. So it will flow automatically down to whoever's listed as the successor beneficiary. So you'll see this with a husband and a wife. The husband passes away. The wife says, I don't want that portion. I want it to go right to the kids. She disclaims it and it flows right down then to the children. That would be a scenario then when the children can have access to those assets. Short of that, then generally speaking, the answer is no. There are some old trust documents that you will see out there that will say that the assets are set aside for the benefit of the spouse and our issue collectively. By the way, that's a terrible idea from a property tax standpoint. Don't ever do that. But that's pretty rare. So the general rule is that the children don't have any access to the B and C trust until after mom has passed away.
Okay, let's go to, we've got about 7 minutes left. Let's go to some of the property tax issues. We talked about Prop 13 before. So maybe just summarize what should do parents leave a house to multiple children?
It happens, absolutely. Did you ask the question, should they do that?
Should they do that?
Yeah, it depends on
I mean, Prop 13 is amazing that you could pass it on, but if you have more than one child, see an attorney, please.
Yeah, while mom and dad are alive, and see an attorney before you make distributions out of the trust. In general, Proposition 13 says that your property tax base, right? The number on which they calculate the property taxes each year, your initial property tax base is going to be equal to your purchase price. And then under Proposition 13, irrespective of the fair market value of your property, your property tax base can only increase or decrease by 2% per year. So that means that if you've lived in a house a long time, you have probably a low property tax base relative to the fair market value of that house. Okay.
And if you got more than one child, see the attorney, because you have to have the equal value in the trust for all 3 kids, or
that's right,
both children.
That's right. So if your intention, and Proposition 58, by the way, says that you have the ability to transfer your house to a child or your children and avoid a property tax reassessment. In other words, your children can step in and own that house with the same property tax base. But what Pete's getting to is, if you've got 2 kids and one of them wants to live there and own the house in his or her name, and the other one wants to sell his or her interest, we've got a Proposition 58 that says you can give it to both kids, and that's an exclusion from transfers between parents and children, but there is no exclusion between siblings. So when the one child then sells to the other, you're going to have a reassessment as to a portion of that house.
Let's go to Prop 58.
Yeah, so this is Proposition 58. So with the principal residence, you can pass along an unlimited amount of property tax base to your children. Doesn't matter what the fair market value is. For everything other than a principal residence, then each parent has $1 million of property tax base that he or she can transfer to the children. So it's not fair market value, but it's the number that shows up on the property tax rolls. So if you've got a commercial property with a property tax base of $1 million, fair market value of $9 million, you can still pass that along to the kids without triggering a property tax reassessment. I'm going to put a little asterisk next to all of this, because in 3 weeks, there are 2 ballot initiatives that are going to affect this. And so I'm telling you what the law is right now, and we don't have time to talk about all the ballot initiatives. But
yeah. What is about Prop 193? This is the one I see rarely used, but it's good to be aware.
Yeah, so it's like a transfer between parents and children. There's also a transfer between grandparents and grandchildren. In order for that one to work, the intervening generation has to be deceased, right? Kind of a sad situation, but we see this happen from time to time. And then this is a big one that pops up, Proposition 60. This allows you to sell your house if you're 55 and older, and to purchase a replacement property. You can then transfer your property tax base to that replacement property and keep that really low property tax base. The rules for this one are pretty crazy complicated. I would say definitely talk to an attorney before you go forward, because if the value of the replacement house is even $1 more than the value of the house that you sold, you lose the whole thing. So again, pretty complicated, and they only apply here in certain counties. The ballot initiative would loosen things up and allow you to do it anywhere in California, but may or may not allow you to use Proposition 58 on a go-forward basis once you take it.
Blaine, what's the easiest way to check on how you're holding title to property?
Well, the easiest way to check on title is to look at your title document that you have, okay?
But let's say you don't have it.
Well, you can go down to the county and you can ask the county for a copy of it, or you can talk to your attorney, and most attorneys have access to some free title search. And so we have the ability, for instance, to run by an APN or an address, and we can pull up and look kind of and get a down and dirty title to see who owns that property right now, how it's titled.
Do you take?
So I can't just look at my property tax bill.
Well, actually, the property tax bill may help you. It will give you a clue, for instance, if it says, Blaine, Searle, trustee, that's a pretty good indication that you've transferred it to your trust. But if it just says Blaine, Searle, you don't know whether or not they got it right. So don't rely on just the property tax bills.
And just a general comment, do most people know how they have title to the property?
The answer to that is probably no.
Yes.
If our clients coming in and showing us title is any indication, then the answer is no. I will tell you, and I think one of your previous speakers already talked a little bit about the different ways that you can take title. If you're buying new property, talk to an attorney or someone, because owning something as joint tenants may or may not make sense. You may want to consider community property with right of survivorship instead. But again, that's kind of beyond the scope of what we're talking about here.
Yeah, well, we got about a minute left. If heir of a trust, a beneficiary of a trust, never receives a copy of it, is there a time limit as to when he or she could possibly get one?
Well, so the trustee is required to send out copies of that.
Well, let's say they don't.
Right. So that heir has the ability, always retains the ability to challenge that trust until 120 days actually after the date at which they actually have a copy of the trust.
What if it's 2 years from now?
Still can challenge it.
Still can challenge it.
If they haven't received a copy of the notice as required by 16061.7, if they don't have a copy of that notice and or they didn't ever get a copy of the trust, then they still may be able to challenge that.
Yeah, that notice is so important. Well, Blaine, you did it. I mean,
All right.
hour and a half, and we got through everything. Don, you want to come back on? Thank you so much. I really appreciate it, Blaine. It was awesome. Great presentation. If somebody has an additional question, could they possibly email you?
Sure, you bet.
Okay. So we had 120 plus participants. Hopefully you don't get 120 emails, but if somebody does have a question, Blaine has offered to answer that.
Is there a size limit, Blaine, on what you would handle as an estate to do an estate plan?
There is not. Again,
Okay.
I'm doing estate plans for newlywed couples who hardly have two nickels to rub together, and we've got clients with hundreds of millions of dollars.
Okay.
Yeah.
I thank you very much. Just as a note, we did start the recording on time and it is still running. So we don't have to do this over like I messed up yesterday. So I thank you very much, Blaine. Thank you, Pete.
Thank you, Don.
Good chatting.
Thank you, Blaine.
Thank you.
We will talk again.
All right.
Alrighty. Bye-bye.
Bye.